Good evening and welcome to Courts Today by Livelaw. This is your host Urvashi Chauhan bringing you the latest updates on the legal front. This is your go-to source for all things legal. Let us start. The Supreme Court today sought response of investigating agencies like Delhi Police, CBI and ED to NewsClick's plea seeking guidelines for search and seizure of digital devices. A writ petition has been filed by digital media platform NewsClick and its founder Prabir Purkayasth, seeking issuance of guidelines regarding the search, seizure, examination and preservation of digital devices and data seized by law enforcement agencies in response to recent raids conducted by the Delhi Police targeting the residence and offices of journalists associated with the organization. The raids conducted under the UAPA resulted in the arrest of Purkayasth and its human resources head Amit Chakravarti. The FIR against the organization under anti-terror laws along with raids resulted in confiscation of digital and electronic devices owned by NewsClick and its journalists. The petitioners contend that these unauthorized search and seizure actions have significantly disrupted their operations. The petitioners have appealed to the Supreme Court, highlighting the absence of explicit guidelines on matters like securing personal devices from tampering, safeguarding privacy, and establishing the duration of seizures, which poses a substantial challenge and infringes upon individuals' fundamental rights. The bench initially expressed its reluctance to entertain an Article 32 plea, but ultimately agreed to issue notice and tag the petition with other pleas seeking comprehensive guidelines on search and seizure of digital devices by investigating agencies. You must be aware that on 18th November, the Uttar Pradesh Food Security and Drug Administration banned production, sale, storage and distribution of halal certified products, citing a complaint filed in Lucknow by a BJP youth wing representative. The complaint alleged that halal certifying bodies issued forged certificates to increase sales among Muslims. The ban is limited to activities within Uttar Pradesh and does not affect the export of such products. Halal certificates signifying a product's permissibility for consumption by Muslims are issued by bodies like Jamaat Ulema-e-Hind's Halal Unit and the Halal Shariat Islamic Law Board. These bodies have strongly criticized the government's decision. A bench of Justices B.R. Gawai and Sandeep Mehta today heard two writ petitions filed by Halal India Private Limited and Jamaat Ulema-e-Maharashtra challenging the ban. The petitioners argue that the ban infringes upon citizens' fundamental rights and disrupts established certification processes. They assert that this move is misguided, leading to confusion for retailers and negatively impacting legitimate trade practices, and that the ban has national implications and affects the freedom of religion. Although initially reluctant to entertain the pleas under Article 32, the bench ultimately issued notice returnable within 2 weeks. The Supreme Court has rejected a plea challenging the Allahabad High Court's decision to dismiss a PIL for recognition of Mathura's Shahi Idgah Mosque site as Krishna Janmabhoomi and removal of the mosque. Advocate Mahek Maheshwari, who approached the Supreme Court, had filed the PIL before the Allahabad High Court, which was dismissed on grounds that the issues raised were already under consideration in pending suits. The lawyer challenged this order in the Supreme Court, asserting that the High Court's dismissal overlooked critical facts and failed to delve into the merits of the case. A bench of Justices Sanjeev Khanna and Dipankar Datta heard the matter today and stated that several civil suits on the same issue were pending and that the petitioner could file a separate petition to challenge any legislation related to the matter. Also, let me tell you, the Mosque Committee has approached the Supreme Court against another order of the Allahabad High Court by which it had allowed an application for appointment of a court commissioner to inspect the mosque. But last month, the top court had refused to interfere with this order when an oral request was made at the bar to grant a stay order. The Supreme Court bench comprising Justices Abhay S. Oak and Ujjal Bhuyan today considered an SLP assailing a judgment of the Madras High Court, which had refused to direct removal of Senthil Balaji as a minister of the Tamil Nadu government due to his implication in a money laundering case. The High Court had noted that as per Representation of People's Act, a person is not barred from holding the post of a minister merely because of pending criminal prosecution and is disqualified if the person is found convicted. The decision was left to the Chief Minister of the state with the observation that if a governor decides to withdraw his pleasure regarding a minister, this should be done in consultation with the Chief Minister and not unilaterally. In the case of Balaji, the Chief Minister had not given consent for the governor's exercise of discretion. The bench today concurred with the High Court's judgment and dismissed the pleas assailing it. In another update, the Apex Court today ordered a stay of criminal proceedings pending in a trial court in Madhya Pradesh against Christian missionary Ajay Lal in a case for alleged forced conversion of two foster children and their parents to Christianity. The petitioner is charged under IPC, the MP Dharmik Swatantra Adhiniyam and the Juvenile Justice Act. The case was registered in response to a criminal case filed by National Commission for Protection of Child Rights based on a viral video where a woman alleged coercion of herself, her husband and children to convert to Christianity in exchange for money, and that they were harassed by the petitioner when they stopped going to the church. There was some confusion regarding an undertaking that was made by the state on the last date of hearing. On 15th December, state made an undertaking that they would not pursue the trial till 5th January, that is today. Senior advocate Kapil Sibal today informed the court that despite the undertaking, trial court continued the proceedings. The Solicitor General explained that the confusion arose because the petitioners stated that the Supreme Court had stayed the proceedings. To avoid additional confusion on this matter, the CJI ordered a stay on further proceedings in the trial until the court addresses it for final disposal. The Supreme Court, in response to the National Investigation Agency's petition against journalist Gautam Navlakha's bail in the Bhima Koregaon case, has extended the stay granted by the Bombay High Court on the bail order. Observing that several connected matters were pending before different benches of the court, Justices M.M. Sondaresh and S.V.N. Bhatti today directed the matter to be listed before the CJI, who will decide whether to include it with other related petitions or consolidate all matters for a single bench hearing. The Bombay High Court, in its December 19th judgment, granted bail to Navlakha, stating that there was no evidence of him committing a terrorist act under Unlawful Activities Prevention Act, that is UAPA. However, the High Court suspended the bail order for 3 weeks upon NIA's request to allow the agency to appeal before the Supreme Court. The Supreme Court today dismissed a challenge to a Bombay High Court judgment which had granted bail to accused Vikram Bhave in the 2013 Dabolkar murder case. Narendra Dabolkar, a rationalist and a social activist, was shot dead by extremist elements on his morning walk in 2013. Bhave was arraigned in the case based on a statement of the accused Sharad Kalaskar, who allegedly shot Dabolkar and claimed that Bhave had facilitated in recce of the spot where the incident took place and had shown him the way to escape from the site. The Bombay High Court had granted bail to Bhave, noting inter alia that there was obvious discrepancy in the proceedings of recreation of the crime scene. The petition challenging the same was filed by Mukta Dabolkar, daughter of Narendra Dabolkar. Today, the bench of Justices M.M. Sondaresh and S.V.N. Bhatti found no reason to interfere with the High Court's decision, saying that adequate reasons had been given in the judgment. To the petitioner's contention that discrepancy in the proceedings was a matter of trial, the Supreme Court bench opined that only a prima facie view had been taken by the High Court. While dismissing a challenge to detention based on the lack of information about rights, the Supreme Court has stated that if a detainee receives the grounds of detention in a language he understands, and it includes a clear statement about his right to make representation, then verbal notification is unnecessary. The court was dealing with a case where detainee was apprehended after information was received regarding a consignment containing gold and foreign currencies. He was arrested but obtained bail. Subsequently, a detention order was passed under Conservation of Foreign Exchange and Prevention of Smuggling Activities Act, and he was detained. As he refused to accept grounds of detention, a panchnama was drawn in presence of 2 independent witnesses, which was signed by the detainee in English with the remark, "I have refused to receive any document." The court inferred that the detainee's claim of not understanding English was an afterthought. It was noted that even a translated version of the grounds was attempted to be served on him the day after his detention. The court, observing that the detainee approached with unclean hands and suppressed material facts, denied him the relief. Explaining the legal position, the Division Bench of Justices M.M. Sundaresh and Arvind Kumar said that when a detainee cannot understand the language used by authorities, a mere verbal explanation would not suffice. Even if he refuses to receive grounds of detention, he has to be informed of the right to make representation. And lastly, a plea has been filed by a woman and her 71-year-old mother-in-law before the Kerala High Court, seeking compensation from the state government for alleged illegal detention by the police for wearing a black chudidar during the Nava Kerala Yatra in Kollam district on 18th December. The woman alleged that she was taken into police custody and was detained for more than 7 hours since she wore black attire. She submitted in her plea that her only intention was to see Chief Minister Pinarayi Vijayan, whom she had otherwise seen only on television and media. She alleged that she was detained only because her husband was a politician belonging to an opposition party. She has also stated that every citizen has the right to wear any color of attire of their choice decently and that she had no intention to create any trouble in the yatra. The single judge bench of Justice Devan Ramchandran will hear the matter next week. Stay tuned with us. Thank you for watching. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.